Right, so welcome everybody to One Chancery Lane's Festive Case Law Updates. Something we attempt every year. It's always chaos, and no less so this year, given that Eddie's already started on the slow gin, something he gave a recipe for earlier, and I'm sure we'll give a recipe for again as we go through if we ask him nicely. On that note, if you have questions, please put them in the Q&A. If you put them in the chat, sometimes we miss them because we're thinking that the chat is just we're chatting amongst ourselves. So if you've got questions, the Q&A is the place to put them. If you want to be anonymous, then just anonymise yourself. That's absolutely fine, no problem at all. If you do stay anonymous when you ask your questions, that means that we can't mop them up afterwards and get back to you, obviously, because we don't know how to get back to you. If you ask questions and you attach your name to them, we'll try and answer them as we go through. But if we can't do that, then it means that if we've got your name, then we can get back to you and drop you a line later on. We're being recorded, as always, and the webinar will be available later on our YouTube channel, as always. So just bear that in mind. I think that's all the housekeeping I need to do before handing over to Eddie. We're going to hear from Eddie about personal injury first, then we're going to hear from Robbie on clinical negligence, me on travel and cross-border claims, Zach on property, chancery and commercial, and then finishing up with Annie on police law. So we've got a lot to get through. I have told the other speakers that I am going to mute them if they run over. So don't be surprised if they suddenly get yanked off your screen and replaced with somebody else. Over to you, Eddie.
Thank you very much, Sarah. Hello, everybody. Happy Christmas. Yes, I have a glass of slow gin. Cheers. So, I've been given 9 minutes by Sarah, and the brief is fast-paced and festive, and as His Honour Judge Sadgerson, once of these chambers apparently said, it doesn't matter what you say, as long as you stop saying it when you said you will. So this is a 9-minute high-octane sleigh ride through the 2021 PI case law, and we're going to start, where else, with duty of care, and the fallout, as I've described it, from Poole Borough Council and GN. There's effectively two cases. The first two were tried together or dealt with together by Mrs. Justice Stacey and the DFX case by Mrs. Justice Lambert. And these were cases in which abused children brought claims against social services for failing to protect them from abuse by parents and their partners. And all of these cases have been struck out on the basis of the analysis in the Poole Borough Council case. And so the pendulum, I think, following Poole, is swinging, certainly for local authority defendants in these types of cases, towards the defendant. In all of these cases, claimants argued that there was an assumption of responsibility by local authorities, and that was unarguable, and the claims were struck out. So next, causation. Well, I've seen that Robbie's going to deal with both of these cases, actually, so I'm going to skip over them really quickly. The Carn and Meadows case, you may all know, it was a 7-judge Supreme Court. Mother wrongly reassured... Hello?
Sorry, go on.
Hello? Is everything all right?
Yeah.
Okay, sorry, Sarah, yeah. Carn and Meadows, 7-judge Supreme Court, all about scope of duty. I'm going to let Robbie deal with that. It's the haemophilia and autism case. I am going to say one brief word or two about Thorley and Sandwell, a decision by Mr. Justice Sewell, just because I completely do not understand it. It has always been my understanding that in order to deploy the material contribution argument in causation, you needed an indivisible injury to which the negligent act or omission had made a material contribution, and then you could claim damages for the entire injury. But Mr. Justice Sewell, persuaded by the defendant in the Thorley case, came to the opposite conclusion. He did say, having recognised that this seemed to be inconsistent with the Williams and Bermuda case, that the issue was ripe for authoritative review in a case where it might affect the result. It doesn't affect the result in Thorley, so there will be no appeal. So who knows when that authoritative review will take place. So there we are. My Christmas gift to you is a case that I don't understand. Right, next. Vicarious liability. Pendulum swinging towards defendant again following the Barclays Bank and various claimants case in 2020. So the XKX case, the local authority placing a claimant in a privately run children's home in the 80s, not liable for sexual abuse by a senior employee, and Barclays Bank very much to the fore in that case. The Jehovah's Witness case is perhaps not a surprising decision on vicarious liability, essentially a leader of the church raping a member of the congregation, and vicarious liability established. But Blackpool Football Club, an interesting case, a really good review of the law on vicarious liability by Lord Justice Stuart Smith, as he now is. And a football club was not vicariously liable for sexual assault by a scout. who worked, a football scout that is, who worked unpaid for the club and who organised a tour to New Zealand during which the abuse took place. The relationship was not akin to employment. There was no sufficient connection linking the relationship between the club and the abuser and the abuse that he inflicted. Next, please. Psychiatric injury. Honourable mention for Paul. This is a case that Laura Johnson in Chambers has been doing. She's currently led by Rob Weir in the Court of Appeal. It's a case about children who witnessed their father having a heart attack about a year after he should have had scans and treatment that should have prevented the heart attack. The heart attack was the first manifestation that any harm had been done to him, and it was a shocking event. They claimed damages for psychiatric injury. Master Cook struck the claim out. Mr. Justice Chamberlain reinstated it, and Laura's just been in the Court of Appeal this week. We expect judgment in March. Just so that you know, heads up on that. She thinks, and her leader Rob Weir thinks, that the Court of Appeal are sympathetic to the claimant's position, but the law is complex and they're not sure what the Court of Appeal is going to do. Occupiers' liability. The Moreira and Moran case is not actually terribly interesting. It's just the owner and occupier of a building not liable when a labourer fell from a mezzanine. The main and subcontractors were liable, so there's no sort of particular injustice there. And that's just a case on the operation of the 1957 Act, pretty straightforward. But the White Lion case, well, this kind of raised an eyebrow when I read it early in this year. The hotel was found liable when a man who had opened the window of his hotel room and then sat on the window ledge to smoke a cigarette fell off, and I'm afraid I can't remember whether he was either very seriously injured or killed. And primary liability was established against the hotel on the basis that the window sill in the room was too low, or lower than it should have been according to building regulations. So he was able to open it and easily get out and sit on the window ledge. There was 60% contributory negligence, but even that seems a little bit surprising, it seems to me. Anyway, there we are. Now, moving on. The illegality defence. So you'll all remember Henderson and Dorset from 2020, I've no doubt. So the ex turpi illegality defence is sort of hot in the news at the moment and being deployed by defendants where they can. The case of Arrow and Gray, it was deployed, I think this is pretty optimistic actually. It was a road rage incident and the claimant was guilty of deplorable, I quote, and disgraceful conduct, preceding the defendant then running him off the road and causing him serious injury. Now the defendant was convicted of causing serious injury by dangerous driving and given a lengthy prison sentence. But chose to run the illegality defence on the basis that what the claimant had done was so deplorable and so appalling that the claimant should not be able to recover damages. And that defence failed. There was no inconsistency or disharmony in the law if damages had been awarded. Now that moves me on to costs, and it gives me the opportunity, I'm delighted to say, wearing the costume that I'm wearing today, to be able to say we've had a big case on cost, and it's ho, ho, ho against Adelekun. I think the APIL were also involved. You'll all know this, I'm sure. No enforcement of the defendant's cost in a Quox case by way of set-off against the claimant's costs. This case resolved an inconsistency in decisions by the Court of Appeal. The facts were that a Part 36 offer was accepted by a claimant. The defendant therefore had to pay the costs. There was then a dispute about whether those costs should be fixed or assessed costs. The claimant disputed that they should be fixed, and the Deputy District Judge, the Judge and the Court of Appeal all agreed with the defendant they should be fixed costs only. So the claimant ended up owing the defendant £48,000 for costs of these various hearings. The original cost the defendant owed the claimant was £16,700, but the defendant was not entitled to set off those costs. Seems to me to be a little bit unfair on defendants, but the reason for it is to preserve access to justice for claimants, as I understand it. And a big note is that you cannot set off a costs liability against the claimant's damages, which you otherwise might be able to do, if the case settles rather than the court making an award of damages and interest, which is something for everyone to think about when they run into a situation where they want to settle a case for a defendant. Interim payments. Stephen and Stephen, a case where a tractor driver was carrying a big seeding machine and collided with a couple of pedestrians. It didn't seem like a very strong defence, but there was a pleaded defence, and Mr. Justice Cotter, as he now is, said that it wasn't quite strong enough a claim to allow him to make an interim payment. Fatal accidents damages, quite a ticklish case this about whether or not you could claim damages for increased dividends from a business that the deceased had set up And this is for family members. And the answer is yes, you can. Even though the family still had the dividends from the business, if the deceased had survived, those dividends would be greater than they otherwise would be, and you're entitled to claim the difference. Moving on to procedure. The Steve Hill Limited case is a case about new evidence in the Court of Appeal under the rule in Ladd and Marshall. It was a fatal accidents act case where the damages, part of the damages, were for the deceased's fostering services. So the couple were foster parents, the deceased foster father died, and so the foster mother had to bring in, oh, there we go, I've had my 9 minutes. I'm sure Sarah's going to give me another 30 seconds. So the mother had to bring in services, and by the time the case got to the Court of Appeal, the foster arrangement had ceased, so the Court of Appeal remitted it to the trial judge. Right, okay, next please. Right, yep. Covey and Harris and Mustard and Flour are cases in fundamental dishonesty claims where the defendant alleges fundamental dishonesty, which you don't have to plead. I was rather thought you did have to plead it, but in fact you don't. So you can make your Section 57 application without having to plead it. And then the rest of my slides are just lists, really. I like the fundamental dishonesty claims because, you know, look, a 9-day trial, 1.5 million, award 17,600, struck out. Look at the Calderdale case, a £350,000 legitimate claim, but a dishonest claim of 5.7 million, struck out. I like fundamental dishonesty cases. And then finally, road traffic. Some good observations on accident reconstruction, expert evidence in Parker and McLaren. Otherwise, there's just a list of cases for you there, particularly those who are dealing with cars versus pedestrians, and contributory negligence of children, 13-year-old boy, 10%, 9-year-old, no contrib, but 17-year-old, 75% contrib. A little bit over my time.
Pretty good, Eddie, I've got to say. For that number of cases, you know, you get a gold star for that. Now you can relax, have a slurp of slow gin. While
I will. Cheers, everybody. Happy Christmas.
Cheers, Eddie.
All right, my turn. I'm going to be looking at clinical negligence cases and covering up a few bits and pieces where possibly skirted over earlier, given the tight time scale that we had. I'm going to start with fundamental dishonesty, also an area of interest in clinical negligence, and a relatively new area in clinical negligence. It's only been a few years since, I think I'm right in saying, the first NHS trust applied to commit a fundamentally dishonest claimant arising out of a genuine claim for medical negligence against it was heard. 3 important cases on FD in the clinical negligence context this year. Idden and Warner, we've already heard about. What that's of use for, a fundamentally dishonest claimant is not going to get out of their claim being struck out on grounds of exceptional hardship, at least not on any basis which the courts have yet identified. There were some pretty extreme circumstances in Idden and Warner, and it wasn't enough. So if you're faced with that kind of claim, it's a good case to cite, something to be aware of if you're for a claimant. Calderdale and Metcalf, a fundamentally dishonest claimant committed for contempt of court. Well worth considering if you're for a defendant. Something, again, to be aware of if you're a claimant. Something a little bit more claimant-friendly now, Brint and Barking. It's a very high threshold to show fundamental dishonesty, or at least there are very specific matters which have to be shown. In Brint, we had a claimant who gave evidence which was completely unreliable and was disbelieved, but there was a finding that the claimant believed the honesty of the evidence that they were giving. That was not sufficient to found a claim for fundamental, or a finding of fundamental dishonesty on. So if you are dealing as a claimant with that claim, look out for that authority and see if there's anything that you can use in your client's behalf, or if you're a defendant, be aware that it isn't necessarily as straightforward as it might at first outwardly appear. Next slide, please. Okay, Khan and Meadows. Ed told you I was going to come back to that. I will. My pick for the most important and most interesting case that I'm going to cover today, if not of 2021, generally, at least in personal injury sphere, Supreme Court judgment, 7-panel judgment. I'm just going to go through the facts because it speaks for itself, and I think it has implications which go a long way beyond personal injury context, frankly. All right. There was admitted negligence on the part of a medical examiner to diagnose a risk of a child being born with haemophilia. The mother carried the haemophilia gene. It's a hereditary condition. The doctor advised that she didn't have the gene in circumstances where, in fact, she did. The child went on to be born and developed haemophilia. Had the mother been told, and the evidence was accepted to this effect, had she been told that she carried the gene, she would have sought termination of pregnancy. So far, so straightforward. The medical examiner was on, or their insurers were on the hook for the costs of treating the haemophilia. This is where it gets more complicated and more interesting. The child also went on to develop autism, and the autism diagnosis was wholly unrelated to the underlying haemophilia. There had been no examination for the risk of autism, no advice sought in that regard. It was a completely unrelated, coincidental condition. Further damages sought in respect of the autism care, and the basis for that claim was essentially that there had been factual causation. Had there been a correct diagnosis, such as the evidence of the risk of haemophilia, the child wouldn't have been born, so those costs wouldn't have been incurred. One can see where the claimant was coming from, but no, it says that the Supreme Court, that claim was refused, and refused on 2 grounds. Firstly, whilst there was factual causation, there was not a sufficiently close factual nexus between the loss which occurred and the negligence which also occurred. And in any event, the negligence in question, diagnosed, was well outside the scope of any duty that had been incurred. So there had been no instruction to screen or advise for the risk of autism. That is very much a potted summary of what is a hugely important authority. It goes to causation. It goes to pure economic loss. Frankly, I think that goes to, you could be dealing with that in the commercial context, never mind personal injury. Well worth reading if you're dealing with any of these fields. It's a standout authority. Causation, touched on by Kahn and Meadows, and increasingly a grey area, and I certainly defer to Ed. I also don't understand the authorities on this one, or even close. And I go so far as to say that there are 2 possibly conflicting High Court authorities. One is Davies and Frimley Heath, and the second is Thorley, we'd already heard about. I'm not going to go through this in too much detail because, as has been established, it seems that there's a conflict in the authorities and that there's no very clear answer to this. My current understanding, such as it is that if you've got an injury which is divisible, so you have aggravation of the pre-existing injury by the tort, it's sufficient to show that there'd been a material contribution. But where there's no such divisibility, the victim dies, it's necessary to show that the death, or as maybe, would not have occurred but for the tort. Now, it said in Thorley, and I think it is also said in Davies, that there is an urgent need for authoritative clarification. Couldn't agree more. Watch this space. Heaven knows when we'll get there. But it looks like that's going to be a thorny issue for the next few years. Another thorny issue for the next few years, vicarious liability. So far, the cases on this deal entirely with dentists who are self-employed within a company structure. So you've got a dentist's practice, which employs, or does it employ, at which self-employed dentists practice. That must also be the case for a GP surgery where the GPs are self-employed. That does happen. It must also be the case for a Harley Street clinic. There's probably quite a number of other similar company structures you can think of, both in the medical and non-medical sphere. What's this all about? It's about vicarious liability of a management company for negligent acts on the part of the individual practitioners. Hughes and Rattan, High Court determination, a finding of vicarious liability or on the part of the owner of an unincorporated dentist's practice for a negligent act of a self-employed dentist practicing there. Perhaps a surprising result, though I do see the force in the court's finding in that regard, but possibly a conflicting authority coming in the Court of Appeal. Corley and Whitecross, the claimant in that case had sued the dental practice and only wished to sue the dental practice and did not wish to sue the individual dentist. The practice defended on the basis that it was the defendant's liability, the dentist's liability, and not theirs. In any event, they didn't know anything about whether there'd been negligence or not. And the Court of Appeal did something thoroughly bizarre in an interim application. It joined both dentists as defendants against the wishes of the claimant. Absolutely bizarre situation, theoretically possible, but not something one sees very often at all. It might be, therefore, that the Court of Appeal is seriously considering reaching a contrary decision to that in Hughes and Rattan. I don't know. Watch this space. We'll probably find out the answer to that sometime in the new year. Last general topic I'm going to look at, going a million miles an hour, expert evidence. 3 cases we're going to deal with on this. The first 2 on this slide. Baidu and Barking. It's a really trite point, but something to be aware of, both for the defendants and for claimants. If you've got a claimant who doesn't seek expert evidence on liability, or if they do and that expert later can't attend trial or can't assist for some other reason, and there's no real prospect of engaging a replacement expert on liability, the claimant normally has, no real prospect of success and is liable to summary judgment. Put that in a sentence, you're not going to get very far without a report on liability and a medical negligence claim. I suspect we may have all known that, but there we go. Authoritative High Court, I think, decision on that point. Weller and Royal Cornwall Hospitals NHS Trust, again, it should be an obvious point, but we've got authority for it now. A neuropsychologist recommended referral to a neurologist. The court at first instance says that was a waste of costs, and one expert could deal with both areas. One suspects that the court wasn't fully appraised of the subtle but important differences between those 2 jurisdictions. Overturned, unsurprisingly, on appeal. In a nutshell, if you have a recommendation by a single expert to another expert, the court will be very reluctant to refuse or reject that advice in case management, or ought to be something to be used if you're dealing with an application of that nature. Last but not least, remember that cost is not the only issue which is relevant to the question of proportionality in dealing with expert evidence, or indeed any evidence. In Paling and Sherwood Forest, you're dealing with an NHS trust which refused permission to have refused permission in a case management decision to have an intrusive test performed on a child claimant in circumstances where that test had only a 20 to 25% probability of being relevant to the trust's liability stance. So if you're faced with an application of that nature, or making an application of that nature, you've got to bear in mind that there are factors other than costs to be considered when you're dealing with proportionality of expert evidence. And I'm not quite sure how I managed that. It's minor miracle as far as I can see, but I think I'm inside time.
Well done, Robbie.
So I will now pass on. Thank you very, very much.
Well done. Well done. Excellent. Thank you, Robbie. Right, it falls to me now. A shiny prize for the person who tells me what it is that I'm looking at here and why it is that I'm referencing it. You will, I think, already have got some clues as to why I'm referencing it in the talks given by Eddie and Robbie, but the law is in such a state at the moment in relation to claims with a foreign element. So claims under the package travel and linked travel arrangements regulations and their forerunner, the 92 regulations. The first and obviously possibly the most important one this year, ex and Cuoni. The Supreme Court has now spoken on this case. You will recall that this is the case of the lady who went on holiday. She was sexually assaulted by a member of hotel staff. Her claim failed at first instance. We went all the way up to the Court of Justice of the European Union to be told that Regulation 15.1 of the old 92 regulations is to be construed widely. That's the regulation that gives rise to the duty on the tour operator and doesn't allow it to raise an independent subcontractor defence, whereas Regulation 15.2 defences are to be interpreted narrowly. Those are the defences the tour operator can rely on as escaping liability there. So perhaps unsurprising for those of us who've been predicting this for the last, I don't know how long, 9 years, that Mrs. X has finally won her case because the hotel was liable for the acts of its servant and couldn't get itself within the 15(2) defence. That it was not liable for the acts and omissions of somebody not related to the package because the tortfeasor was an employee of the hotel. So X and Q only are successful claimants, but there is a further costs argument on that. So X and Q only is, as far as I know, still ongoing. 9 years it's been, and she's been all the way up to Europe and she's come all the way back down again to the Supreme Court, and we are still arguing about it. Griffiths and Toohey, this is another one to watch. It's come in from the Court of Appeal. An uncontroverted expert's report can be impugned in closing submissions and can be rejected by the judge. You'll remember that in the High Court judge said that if a report is not challenged in Part 35 questions or in cross-examination, the judge is bound by it effectively. The Court of Appeal doesn't agree, but Lord Justice Bean gave a very, very strong dissenting judgment, which I think may throw the claimant a lifeline, because in his dissent he said that he felt the claimant had not had a fair trial, or that rather the claimant might feel and might justifiably feel that they had not had a fair trial. And I think that may give rise to permission from the Supreme Court. It would seem a bit unlikely, if you've got a Lord Justice saying there's been an unfair trial, that that will be the end of it. Claims under Montreal and Athens. This is a really important case, Silverman and Ryanair, quite recent. This is Master MacLeod talking about the applicable law under the conventions. And we've been fudging this for years, for decades, as to how you quantify damage under the Montreal and Athens conventions, because, of course, they are standalone international conventions. They stand outside domestic law. But you look at Rome 1, so it's the tort law that's the important one under the conventions, not the contractual law that you look at in relation to quantification. Well worth looking at. That was a Montreal case, but it will apply to Athens as well. Obviously, no talk on travel would be complete without reference to Brexit. We Brexited this time last year, and notwithstanding that, the applicable law rules in Rome 1 and Rome 2 remain operative, but we are Brusselsless. So in answer to the question from Paul McClory as to whether or not Christmas lunch will be better or worse under Brexit, it really depends whether you like your Brussels or not. We don't have the same jurisdictional rules that we had this time last year, and that has cast jurisdiction into a degree of flux. The government has now announced plans to bin Vanook liability. You'll remember Vanook was the European Court's decision on road traffic insurance, which held that insurers had to insure on private land and on vehicles that were used on private land and vehicles used primarily for purposes other than transportation. The government is going to bin that, although quite what it looks like we do not know yet. Remember that even though jurisdiction has changed, the Civil Jurisdiction Judgments Act has been amended and the rules on consumers and employees remain the same. So consumers and employees have more advantageous jurisdiction rules than the rest of us. There have been a number of cases on jurisdiction this year arising out of both pre and post Brexit cases. Chowdhury talks about temporary residence abroad for the purposes of accessing healthcare, and whether or not the claimant can still be resident in England and Wales for jurisdictional purposes, even though they're abroad getting healthcare. The answer to that is yes, but that case is being appealed, or permission is being sought in the Court of Appeal. State and Cosmos, similar question to do with temporary presence abroad as a member of the armed forces. Can you still be resident within England and Wales for jurisdictional purposes, even though you're posted abroad? In that case, the High Court said no, that is now leapfrogging to the Court of Appeal. And it may be that Chowdhury and State might be conjoined, because the appellants in Chowdhury are asking to join with State because they say they raise similar questions about presence, physical presence and residence in jurisdictional contexts. Again, in relation to jurisdiction, another very recent case, this one's from Europe, Tassel. It was actually referred up from a district judge in England all the way up to the Court of Justice, and it reverses the Keefe insurer anchor. This is really important, certainly for pre-Brexit claims, that if you're able to sue an insurer in this country, you can't, by doing that, anchor their insured. So in cases where one of the defendants is the insurer and the other one is the insured can get out of jurisdiction as a result of this case. IDNLU, submission of one defendant to the jurisdiction doesn't anchor another. So where your anchor defendant has submitted unnecessarily to the jurisdiction, the other defendant can still challenge jurisdiction notwithstanding that submission. And of course, any discussion about jurisdiction would be entirely incomplete if we didn't talk about Brownlee, another case that has accompanied us for a decade and is no closer, I think, really, to being resolved than it was before, save that we have confirmation that the court has jurisdiction because indirect loss suffered within this jurisdiction is enough to satisfy the old tort gateway. And I think we know that we've always known that it would be enough to satisfy the new tort gateway because the rules changed during the lifetime of the case. But also, and interestingly, it restates the principle in Bumper Corporation that foreign law is the same as English law. And there's an interesting discussion in Brownlee about that presumption and also about how you plead foreign law and whether it's necessary to do that. Is it the end of the Brownlee litigation? I should cocoa. Of course it's not. Lady Brownlee's now got, she's now established that the English courts will have jurisdiction. Now we'll move on to questions of limitation under Egyptian law, and we'll move on to questions of liability. So this is far from the end of Brownlee, I think. No discussion again of cross-border claims would be complete without some coronavirus. We have had one case from Scotland, which is the Dumfries and Galloway case. This is a case determined on standard terms of a school trip tour operator contract. And I think I'm right in saying it was under the old regulations, but the local authority was entitled to a full refund under the terms of the contract, which mirrored the package travel regulations. This is not going to be the final word on cancellation under the regulations. There are a lot of cases queuing up, waiting to be heard in relation to cancellation of holidays, in relation to significant alteration of holidays. Lewis Solomon asked us, where are we now with regulation 12.7? I suspect, Lewis, the answer to that question is that you know the answer better than I do because you're doing these day in, day out on the ground. I haven't seen any higher authority in relation to regulation 12.7 on cancellation of holidays resulting from COVID, but I have got one going at the moment through the county courts, which relates to cancellation, not for COVID reasons, but for other reasons, and that will revisit your right to cancel a holiday and what happens when you do. I think I came in within time there. So without further ado, I will pass you on to Zach.
Thank you, Sarah. I bought my egg timer of doom, which I'm going to set now. I'm going to give myself 20 minutes or so to talk about property cases. So going to cover sort of 7 areas or so. The big point at the beginning of the year was the first decisions on the rent arrears and COVID cases. So various tenants unable to trade by reason of the COVID regulations were sued. Summary judgment applications were made for their rent arrears, and the first 2 decisions, Mellon and Commerce, were dealt with by masters. And the arguments in those cases turned on things like the non-compliance with the code of practice for commercial property, interpreting the rent cessor provisions in the leases, arguments about whether in terms should be implied, and the tenants in those 2 cases failed completely. London Trocadero is a September decision by a deputy judge of the High Court. That's a bit more interesting because the tenant was also running an argument, an unjust enrichment argument, saying that each gale of rent, each tranche of rent was a severable part of a contract. And if they couldn't use their premises as a cinema, then there'd been a failure of basis and they were entitled to an unjust enrichment claim. What's interesting about it is that the judge gives some time to that and asks 3 questions. Firstly, has there been a failure of basis? Secondly, was the failure of basis related to a severable part of the lease because the contract was continuing? And thirdly, was there a defence? The judge decides that there wasn't a failure of basis because the risk of the property not being capable of being used fell on the tenant. But what he did say was that potentially a failure of basis might relate to a severable part of a lease. So there's some comfort for someone else who wants to run the argument. And then if you were able to get home, it wouldn't be a defensive rent claim, but it might provide a counterclaim. Can I have the next slide please, Sarah? So the next slide deals with two cases which relate to CVAs. CVA, of course, in this month at any rate, stands for Christmas virus again. Other times of the year, it relates to creditors' voluntary arrangement. And the issue for landlords with CVAs is that when a CVA is proposed, very often all the creditors are drawn into the CVA and able to vote for it, but they are treated differently by the terms of the CVA. In particular, landlords might be told that the past rent is going to be compromised and that future rent they're going to have received less rent than is due under the lease. So the arrangement actually has the effect of varying the leasehold interests. And to get your CVA approved, you need 75% of the creditors by value voting for it. And the complaint of the landlords is that the non-landlord creditors are voting in favour of the arrangement and getting a better deal than the landlords. So Mr. Justice Zachary dealt with two cases, gave judgment in the New Look case first of all, and there's first of all was a jurisdictional question as to whether or not this type of arrangement where you're treating subclasses of creditors differently was even permissible in the CVA. He held it was. And then he gave quite a lot of guidance on the basis in which you can challenge it as to whether or not there was unfair prejudice or a material failure in the procedure by which it had been reached. Virgin Active Holdings is interesting because the following week of the New Look case, Mr. Justice Zachary found that there had actually been unfair prejudice in that case because one of the creditors, who was an uncompromised creditor, so they were going to be paid in full, had voted for the arrangement, but when their position was examined more closely, they should not have been treated as a critical creditor because they had other funds than coming from the company to pay a debt to a higher company up the chain, which was said to be threatening to terminate various franchise arrangements, which would prevent the Regis brand of salons trading. So there is scope for landlords who look carefully at the background to challenge these CVAs, but the principle that landlords can have the rent varied is certainly established by the first case, the New Look case. Next slide, please, Sarah. So two cases on forfeiture. Fays and Burnley deals with the situation about waiver of forfeiture. Waiver is really an example of election. You've got a choice of remedies. Do you choose to forfeit where the tenants breach the lease, or do you treat the lease as continuing? One way you might treat the lease as continuing, where if you know about the breach, you make a demand or accept rent. And Fays and Burnley comprehensively confirms that by accepting or demanding rent, which has fallen due after the breach, in this case a subletting of a cafe, that before the landlord knows about it, you have not waived your right to forfeit. So that's Court of Appeal authority on that for the first time. There's also an interesting side issue in Fays about a second demand for the insurance rent in that case, which is worth looking at if you've got a client who has made a second demand, having found out a little bit more about what the tenant's been doing. Keshwalla is a very sad case. Again, a cafe. £500 of rent was left outstanding by accident by the tenant. The landlord peaceably re-entered and the tenant paid the money. Under section 139 of the County Courts Act, the County Court had jurisdiction if the tenant made an application within 6 months to get relief from forfeiture. But that relief is discretionary, and the jurisdiction is that it has to be, you have to make your application with reasonable promptitude. For reasons best known to the tenant, it left it until nearly 5 months before making its application, in which time the landlord had granted a lease to a new tenant. The first instance judge said this is too late. You have not acted with reasonable promptitude and rejected the application. First appeal was more sympathetic, but the Court of Appeal have now restored the first judge's view that you can be within 6 months but not have acted within reasonable promptitude. Next slide, please, Sarah. So we've already heard about Meadows and Khan. So these are the back-to-back professional negligence cases given by the Supreme Court. Manchester Building Society and Grant Thornton deals with a situation where the Building Society was advised by Grant Thornton that it could enter into certain interest rate swap regimes, transactions. And what this case really nails on the head is the distinction for the Samco cap between advice on the one hand, where you're liable for all the consequences of the loss of the transaction, and giving information where under Samco you were said only to be liable for the consequences of the information being wrong. Lord Sumption in a previous case had said that was not a satisfactory distinction, and the Supreme Court really removed that as being a distinction. And what the focus on now is the extent to which, as a professional, you accept responsibility for the transaction or the decision-making process that the client makes. And the court also provide a sort of a 6-pointer guidance for anybody who's asking themselves the question, is the professional liable for this particular loss? So it eventually provides a starting point for anyone looking to see in a sort of a novel situation as to whether or not the professional is going to be liable for the loss that you've suffered. Next slide, please, Sarah. Rent repayment orders, or RROs, ROs. Rackerson and Jepson, the Court of Appeal, decided that you cannot get a rent repayment order against a superior landlord. So you get a rent repayment order if your landlord has committed a certain offence, that there's then a period of time in which the rent referable to that period of time can be ordered to be repaid. Because you can't get it against a superior landlord, it's very easy to avoid rent repayment orders, because if you are a dodgy landlord, you simply grant a tenancy to a company which might be connected with you, and that company grants the residential tenancies, and that company is the party which is liable to the rows of the rent repayment orders. Vicarious and James are the next one, and that concerned a situation where the landlord, the immediate landlord, was not only in breach of having not got a license because the HMO was in an area which required additional licensing, they'd also harassed the tenant and they'd also unlawfully evicted the tenant. So there were 3 criminal offences that had been committed, and the tenant wanted to get not 1 but 3 rows. So it wanted a row. And the upper tribunal held that the way that section 44 is drafted, that is not possible. So the tenant was able to get a row, but sadly no row. Next slide, please, Sarah. Then rounding off with just 2 sort of not cases. First of all, one on estoppel by convention. Tinkler and Revenue of Customs and Commissioners says that estoppel convention can arise in non-contractual cases, and you apply the same tests as you would in a contractual case, which is set out in a case called bench dollar. And what is particularly interesting is the idea that to rely on an estoppel by convention, the party relying on it must have done something to assume responsibility for that convention, and to indicate the other party can rely on it. So in Tinkler, the Revenue had started an assessment, an inquiry of a particular tax year. They'd sent the notice to start that to the wrong address, but the accountants for the taxpayer had then responded to it and engaged with it, and that had established the estoppel by convention. Next slide, and last slide, please, Sarah. So this is Les Ambassadeurs. Mr. Songbo Yu had gambled at their club. He'd cashed cheques for £19 million worth of credits at the casino, and then his cheques had bounced. He had reached a settlement agreement, which he then hadn't complied with, and had been sued, and Les Ambassadeurs, I think, got summary judgment. I think 10 million was still outstanding. After getting judgment, Les Ambassadeurs wanted a freezing order, and that was refused. The appeal was on the basis that the judge had applied the wrong test, that he hadn't considered, oh, that's my time gone. He hadn't considered whether or not the risk was more than fanciful, and the Court of Appeal says, no, the test is simply, it's a real risk of unjustified dissipation with no gloss on it, and a simple failure to pay when you could pay probably isn't going to be enough. So that's me done. Thank you very much, everyone. Merry Christmas.
Well done, Zach. Annie, you're up.
Thank you, Zach and Sarah. I'll be addressing two key police law cases today concerning youth crime and criminal records. Now, these cases are of the utmost importance to police practitioners, but will be of use to practitioners who deal with human rights and data protection more generally. The first case is AM and the Chief Constable of West Midlands. It was about a youth who challenged a finding that he had breached an antisocial behaviour injunction. And the injunction in question ordered that he was forbidden to enter certain parts of Birmingham. He challenged this injunction on the basis that the procedure for ordering it was flawed. Next slide, please. I've set out the grounds on this slide. First, that the Chief Constable should have consulted the local youth offending team before initiating breach proceedings. Second, that the consultation was inadequate. And third, that the injunction lacked clarity to be sufficiently enforceable. Next slide, please. Now, all these grounds were rejected by the High Court. Under the Act, the Chief Constable was only required to consult a youth offending team before applying for a supervision or detention order. There was no obligation to consult the team before an arrest or a hearing in court. Second, the consultation in question was adequate. All relevant evidence and material had been provided, and there was no evidence before the court that the team considered that proceedings should not be pursued. And finally, the injunction was clear and precise. It made it clear that the youth in question could not enter an area outlined in red on the map. Next slide, please. So what can we take from this case? Well, I say that there are two practical tips that should be dealt with. The first is that the statutory duty to consult in the 2014 Act must be taken seriously. With respect to injunctions, it is important to engage with the youth offending team and provide all the relevant evidence in advance of the consultation. Secondly, with regard to antisocial behaviour injunctions, it cannot be understated that these must be clear and precise. In particular, it's useful to note that the judge in question found that shading an area of a map was a proportionate way to indicate a prohibition on entering. Next slide, please. The second case which I shall deal with is QSA and the National Police Chiefs Council. The claimants in this case were three women who had been pimped into prostitution at a young age, and they all had multiple convictions for soliciting and loitering. Earlier on, they had achieved a landmark victory where they had successfully challenged the disclosure and barring scheme, which had required them to disclose their offending history when applying for a range of jobs. However, that victory did not prevent their criminal records from being retained on the police national computer until they were 100 years old, and a record of them could still be disclosed within the criminal justice system and for a limited range of other purposes. They challenged this decision by way of judicial review, claiming that the policy, the blanket policy in fact, interfered with their rights under Article 8 ECHR to privacy and was not a proportionate or lawful interference. This claim was rejected. Next slide, please. Storing information on a database clearly engaged Article 8 of the ECHR. On lawfulness, it was found that the appropriate test was that set out in Gallagher. It had to have some basis in domestic law, the measure had to be accessible to the person concerned, and be compatible with the rule of law. And this was satisfied in this case. On proportionality, the test was whether the database was proportionate because it did not allow for exceptions. At this stage, it might be worth reminding practitioners about the appropriate test for proportionality in human rights claims. This was outlined by the Supreme Court in Bank Malat, and any analysis of proportionality must consider 4 factors. Firstly, the decision maker must outline the objective of the measure. Secondly, you must ask yourself whether that measure is rationally connected to the objective. Next slide, please. Thirdly, and this is important, could a less intrusive measure with regard to human rights be used without compromising the objective? And lastly, does the severity of the measure's effects outweigh the importance of the objective? Next slide, please. The court found that the measure was proportionate. A comprehensive criminal record was useful for a variety of reasons. This included engaging in various stages of criminal proceedings, recruiting covert human intelligence sources, and vetting procedures. Any less intrusive measures would have resulted in an incomplete criminal record, and ultimately this concern outweighed the claimant's personal interest in deleting their past conviction from the national database. Next slide, please. This is the final slide. This case is a useful reminder for all practitioners dealing with data protection law, and particularly those engaging on behalf of local authorities. It shows and clarifies how to assess whether an interference with Article 8 can be justified. And importantly, this case clarifies that the lawfulness criterion only concerns the accessibility of the measure. It is the balancing exercise of proportionality that is likely to be more controversial. Practitioners should be alive to the question of whether there are less intrusive means of the measure being implemented without unacceptably compromising the achievement of the objective. And that concludes the police law aspect of this presentation.
Well done, Annie. That was great. What an extraordinary case.
Yeah.
Right, have we got any questions? Let's have a look. Since we've got a couple of moments. Yes, Doctor Who flux, absolutely. Whoever that anonymous person is, because the law is in flux. Brilliant, brilliant. I'm so brilliant, I was surprised myself. Whoever you are, if you want to email me with your address, I will send you a little prize, because there ought to be prizes at Christmas. So well done to the anonymous person for guessing what it was that I was banging on about. I'll take you back to it, shall I, just so that everyone can see it. And any sensible or not sensible questions, we've got 2 minutes. Yeah, 2 minutes. So we can attempt to answer them on any of the cases or issues that we have raised. Oh no, that's coronavirus. Nobody wants to see that again. Well, I suspect we all will be in the days to come. Any questions? There you go. There's the flux.
Someone called Richard Cherry has asked a question. He asks, is it true that Sarah Prager just gets wiser and more beautiful? And Richard,
yes.
The answer to that is yes.
Yes, clearly the answer. Well done, Richard. So you got that bottle of gin I sent you in the post, obviously. Any other sensible and perceptive questions such as that? Yeah, answered live. Slow. Thank you, Imogen, for thanking us. You're very welcome. Any other questions for anyone? Otherwise, we will draw this to a close. And thank you very much for attending. We know it's a lot to get through. We know it's all a bit sort of one case after another. You will get the slides in the recording, which, as I say, will also be available on YouTube. But thank you for coming along and putting up with us, and putting up with us as we canter through the case law from 5 different areas in an hour. Thank you, guys.